Hey everybody, what you should have be in front of you at this point is the exclusive buyer-tenant agency contract. This one's going to be typical of all the others, and what you will see that simple things, contract date through the expiration on. I'll give you a guideline that says probably, look, I'm recording this in June of 2026. At this time period, this market, I would say that 60 to 90 days is a good length of a buyer representation agreement. Otherwise, I want you to think of it this way. How long will it take for a buyer or an actual tenant to be able to find a home? A tenant, guys, hopefully that's 30 days or less. But a buyer, somebody who's ready, willing, and able to buy. Well, how long does it take to get them under the contract of a purchase agreement and closed? So that's the basic thoughts to it. Other classes we'll get into it and we'll share with you more in regards to that philosophy. Now, obviously, I am using a Coldwell Banker one. If you're Century 21, you will have the Century 21 professionals in this particular spot. We get into the aspect of designated agent. That's going to be you, obviously. Your email address, your phone number. Supervisory broker, again, you need to be able to talk with your managing broker. Should that be them or potentially Chris Hendricks or someone else? But you need to find that out from them. We're going to put that in that blank. Buyers, who are they? Put in their names, their home address, their email addresses, and their phone numbers. From there, it is stating what the scope of the exclusive agency is. And as it says, broker and buyer agree that the broker shall act as a buyer's exclusive agent in connection with the buyer's possible purchase of the following property. We would love to be able to check off all of the time any real property located in Michigan. However, there are going to be circumstances where the appropriate blank is going to be the following specific properties only. And you're going to insert either a single address or the addresses of the properties that you are showing. Because what it is stating is that should they buy one of these properties, they owe you compensation. So list those addresses out. Designated agency. We have to state because we are a designated agency company. Broker and buyer hereby designate the agent or agents named above as the buyer's designated agent. Buyer shall have an agency relationship only with that broker, us, and the designated agent and supervisory broker named above. That buyer acknowledged that neither the designated agent nor the supervisory broker are acting as attorneys, tax advisors, surveyors, appraisers, environmental experts, or structural or mechanical engineers, and that the buyer should be contacting professionals on those matters. It also goes on to make sure that they understand that neither you as a designated agent or the supervisory broker is in a position to advise the buyer as to the location of any property within a floodplain. So this is kind of a, we're protecting our backside. Buyers encouraged to visit the website, and we give it to them to be able to find out about whether or not any particular home is within a floodplain. Now from there, it states that the exclusive agent, that the buyer agrees that during the term of the agreement, any and all inquiries or negotiations on behalf of the buyer relating to the acquisition of any desired property is to be done through you, the designated agent. So if they find something, they need to come to you to be able to put that offer in and have you negotiate on their behalf, is the example of what that's really covering. Now, from there, we move on, and this is a very important part, and that is your compensation. They do not pay you a commission, they pay you compensation. Broker's fees for services rendered is not fixed, controlled, or recommended by law, the MLS, or any person not a party to this agreement, and is fully negotiable. Now, have a little bit of fun here, guys. I love to be able to go to a buyer and just say, yes, my fee can go up. The same as I would do is, yes, it's fully negotiable. It can go up. And then give them a smile. Typically, that takes care of anything that comes up with negotiation. But this is required verbiage that we must have part of our agreements. Now, from there it says, broker may not receive compensation for brokerage services provided to the buyer from any source that exceeds the amount. So we can only get what we have an agreement to with the buyer. We cannot take more. Now, we could take less, but we cannot take more than what we have agreed upon. So let's see. Could we change that? Yes, but I find it hard to believe why a buyer would say, sure, go ahead. Make more money instead of putting it in my pocket, getting me a home for less. Doesn't quite make sense. In consideration for the services to be performed under the agreement, buyer agrees to pay broker as follows. In the event that the buyer contracts to purchase the desired property, the buyer agrees to pay broker 3%. Now, that is the company guideline. That's what we want everyone to be able to procure, is that 3%. And that is of the sale price. It could be a flat amount. Now, along with that is $495 for the sale. If it's a lease, it's $195. If anybody says, what is that for? Well, as you can see, Mr. and Mrs. Buyer, my total compensation is 3% of the purchase price plus $495. Yes, but what is that for? For my compensation. That's all. They just got to keep it simple. All right. Now, the compensation is due and payable upon closing, provided, however, that if the transaction does not close because of any default on the part of the buyer, the compensation shall become due and payable. Compensation obligation shall apply to the purchase agreement executed during the terms of this agreement or during any extension of this of this agreement. The compensation obligation will also apply to purchase agreements executed within, and this blank goes, 6 months. We don't want to go any longer than 6 months. Now, let me rephrase that. You can go longer than 6 months. We don't want to go any less than 6 months. See, we want to create a little pain. If they're going to try to play any shenanigans on us, they're going to have to wait 6 months to be able to make that happen, becomes the bottom line. Now, that's after the expiration or termination of this agreement if the property acquired was presented to the buyer during the term of this agreement. So if they were to go purchase something that we had showed them, within 6 months from the expiration, they owe us compensation, becomes the bottom line. Now, from there, we want them to actually make a choice. Most are going to say that the buyer will have the seller contribute to the buyer broker compensation through their offer to purchase. And as you know, or you will know, you'll see that on the purchase agreement. But the buyer does have the right, if they have the ability, they can pay that compensation directly. Let's move on. Number 5, page 2, is about the compensation credit. Buyer will receive a credit against any of the amount that they owe pursuant to paragraph 4 for any compensation paid to the broker by the seller or the seller's listing broker. So it just says, Mr. and Mrs. Buyer, if you get money from other sources, it gets credited toward that amount. We are always going to, kind of direct the buyer, guide the buyer to get the compensation as part of their purchase agreement. Now, we also have to make sure that we disclose what our role is. And that's the reason that this is on the agreement. It says that any time of any initial contact, the designated agent shall inform all prospective buyers and their agents that the designated agent is acting on the behalf of the buyer. Designated agent and the supervisory broker will preserve any confidential information obtained during another agency relationship. So we're letting them know confidentiality is always at 100%. Buyer acknowledges and agrees that the preservation of this confidential information shall not constitute a breach of any fiduciary duty owed to the buyer. Now, this is what makes this a sale or lease agreement for the buyer. It says anything that deals with buyer stuff means tenant stuff. Anything with tenant stuff means buy stuff. So it's a catch-all paragraph. This agreement also applied to situations where the buyer wishes to lease or option property. In those situations, the terms used shall automatically be changed as appropriate, so the term purchase shall mean lease. Rent or option shall mean, term shall mean, the lessor. You guys got it. You can read the rest of this. Now, from there, we're going to deal with conflict of interest. Otherwise, where you have the concern of what if I'm in a dual agency situation. We know that as a company, we're okay as long as we do dual agency correctly. So this states that if there's a conflict of interest with other buyers, here's what it states. Buyer acknowledges that the designated agent may represent other buyers desirous of purchasing property similar to this buyer's desired property. They acknowledge and agree that the designated agent, you, may show more than one buyer the same property. And then not only that, that you may prepare offers on the same property for more than one buyer, whom you represent. Designated agent shall preserve any confidential information disclosed by any buyer client and shall not disclose the existence of or the terms of any offer prepared on behalf of one buyer to another buyer. So it's telling you what you can do. It's telling them what you can do. It's telling them what you and they can't do. In the event designated agent works for two competing buyer clients in connection with any specific property, oh, it's not fun when you have it, but it could come up. Designated agent will be working equally for both buyer clients and without the full range of fiduciary duties owed by a buyer's agent to a buyer. You'll know from being in a buyer's class that we do through the business development series, you understand how this is possible. In this situation, the competing buyer clients are giving up their rights to undivided loyalty because we are minimized by the dual agency, and giving up their rights to undivided loyalty and will be owed only limited duties of disclosure, obedience, and confidentiality. Not sure that you understand that completely? Join session 2 of the next business development series, where we always discuss agency in general. Let's move to paragraph 9. This is the conflict of interest regarding sellers. A particular seller is represented by another agent designated within the brokerage other than the designated agent. Broker and supervisory broker shall automatically be deemed disclosed consensual dual agents, but not you in that situation. Here's where you get it. If a particular seller is represented by the designated agent, designated agent shall act as a disclosed dual agent of both the buyer and the seller. And what you know is you must redisclose your agency relationship because it has changed. In such an event, broker shall be entitled to any fees owed by buyer pursuant to this agreement. Disclosure. Buyer agrees to disclose to the designated agent all relevant personal and financial information to ensure that the designated agent and the buyer have the ability to complete any transaction which is the subject of this agreement. Buyer hereby grants designated agent the authority to disclose such information as the designated agent deems necessary or appropriate in order to influence the decision of a seller to accept an offer. I think that's pretty much very clear. When we're not going to put the buyer at a disadvantage, we can disclose certain information when it puts it to their advantage. Cost of services products obtained outside of these sources, we're not going to get anything outside of unless the client agrees to pay for them immediately when payment is due. So they have to do their surveys. They have to do certified environmental studies, I should say. Pay for these when they do them. Soil tests, so on. Indemnification, great thing to be able to have for us on a legal side of things, and it just says buyer agrees to hold us harmless. Indemnify us, you, the designated agent, supervisory broker on account of any and all costs or damages arising out of this agreement, provided no one at the brokerage firm is at fault. Subject obligation to include, but not limited to, reasonable attorney's fees and costs. Non-discrimination, guys, it's just a basic clause that stands in all of these things. It's always going to be there. Always going to be there. Here's what we know. You've heard me say it plenty of times before. Everybody's money is green. Therefore, we will take and make sure that we treat all parties exactly the same. Counterparts, well, this is a simple one, just saying that you could have 5 copies, all of them signed, and all of them have the same effect. We must, going to paragraph 15, page 3, disclose our duties to the client. Again, if you've been through my agency course, here's what you know. Old car or old card. These are simply our fiduciary duties that we owe a buyer. Confidentiality, obedience, reasonable care and due diligence, accountability of the funds, loyalty, disclosure, and they acknowledge that in case of a dual agency situation that these are going to be limited. That's paragraph 15, but it has to be part of the agreement. Paragraph 16 is stating to them to make sure that they know and understand that electronic communications are binding. These are signatures, initials, and things that go along with that. Paragraph 17 is about the condition of the property, that the buyer is not relying upon you as a designated agent to determine the suitability of the desired property for the buyer's purposes or for regarding the environmental or condition of the desired property. If they're going to rely on somebody, it's got to be someone else other than you. Now, that doesn't excuse us of all of our fiduciary duties. We still have things that we must do in regards to knowing and what we must exercise. As far as limitation, buyer and broker agree that any and all claims and lawsuits between the parties to this agreement must be filed no more than 6 months after the termination of this agreement. Parties waive any statute of limitations to the contrary. This 6 months flows all the way through all of our agreements. As far as paragraph 19, merger. Buyer and broker agree that any and all claims the agreement constitutes the entire agreement between the parties, and any prior agreements, whether oral or written, have been merged and integrated into this one agreement. So it's just stating this is it. If there's something not on here that you thought we agreed to, it needs to be on here. And of course, that's the same thing with you. As with other agreements, and in particular, I'm referring to our listing agreement. With cancellation, number 20 states this agreement can be canceled or revoked. But notice we've underlined only by mutual consent of the parties in writing. So a buyer just can't go and say, you're fired. Doesn't work that way. There has to be an agreement between you, meaning the brokerage, and the buyer. Now, obviously, that also means this. You can't just fire the buyer, even if you'd like to, and believe me, there will be somewhere you'd love to do that. Paragraph 21. Let me just throw it out that this is a simple one. Paragraph 21 is an opportunity for you to be able to make any other additional terms that would be suitable to the buyer and acceptable to you and the brokerage. From there, just as simple, it says, hey, you've got a copy of this buyer. Make sure that they do receive that this is done by Coldwell Banker professionals or Century 21 professionals. You are to sign as the designated agent, and of course, the date that you've signed it, along with the buyer's signatures and the date where they have signed it. So, guys, that is the exclusive buyer-tenant list or agreement. Oh, you always want to say listing. I hope it all makes sense. You got questions, check with your managing broker, your mentor. Somebody's going to have the answer. Out with that, you need to go talk to people, get some contracts signed, get these ones signed.